There are 6 documents that stop the IRS from taking your home after you die, and the moment your heart stops, the government has 9 months to file a claim against everything you own. 9 months, not a year, not 5 years, 9 months. Every American homeowner over 60 is exposed to the same risk right now. 9 out of 10 have filed none of these 6 documents. 9 out of 10 families will sit in a courtroom one day and learn for the first time what those forms would have saved them. The legal system was not built to warn you about this. It was built to collect from you when the moment arrives. The IRS was not built to help your family. It was built to collect taxes. Probate court was not built to honor your wishes. It was built to generate fees. Every year, the two of them take tens of thousands of dollars out of estates that the family spent a lifetime building. The home you paid off in 1998 becomes a check written to the government, sold at auction, or split between attorneys who never met you. Most families never hear about these documents until they are sitting at a kitchen table, planning a parent's funeral, listening to a probate attorney explain why the house has to be sold, to pay a tax bill nobody warned them about, until it is too late to do anything about it. Each of these 6 documents costs less than $500 to file. Some are completely free, but if you do not know they exist, the IRS gets the house, the court gets the fees, and your children get the bill. The 5th document on this list is the one 9 out of 10 seniors have never even heard of. Stay with me for the next few minutes because that document is the difference between your children inheriting the home and the government selling it at auction to pay a tax bill 9 months after the funeral. I am going to walk you through every single one of these 6 documents. I will tell you the exact dollar amount each one saves, the 9-month deadline each one beats, the states where each one works, and the order to file them in. By the end of this video, you will know exactly what to do this week. Let us start with why this is happening in the first place. The probate court system in America handles about 30 million estates every year. Around 2/3 of those estates had no planning at all, no trust, no will update, no deed. The court steps in and decides what happens to the home, the bank accounts, the investments, and the car. And every step of that process carries a fee attached to it. The total cost to a family can reach 15% of everything the deceased person owned. On a $400,000 house, that is $60,000. Some of that goes to attorney fees, some goes to executor fees, some goes to court costs, a piece of it goes to state estate taxes, another piece of it goes to the IRS. Because the moment the estate is opened, the IRS clock starts ticking. 9 months. That is the government's deadline. Penalties start accruing after that. And here's the part nobody talks about. The home where your kids grew up, the home where your grandkids took their first steps, the home you worked 40 years to pay off, that home can be sold out from under your family to pay a tax bill nobody warned you about. It happens every single day in every single state in this country. And it keeps happening because the system does not advertise the documents that would have stopped it. The first document is the transfer on death deed, and it is the one that saves $9,000 to $21,000 in probate fees on most homes. A transfer on death deed is a piece of paper you sign and record with your county recorder's office. It names the person who gets your house when you die. What it does is one simple thing. The day you die, the deed automatically transfers the house to the person you named. No court, no judge, no 6-month wait. The county just changes the name on the title. Nothing more, nothing less. Here's how it works. You go to your county recorder's website, you download the form, you fill in the name of the person who should inherit your house. You sign the deed in front of a notary. You pay a recording fee, usually between $50 and $200. You keep 100% control of the house. You can still sell it, you can still refinance it, you can still live in it. And if you change your mind, you can revoke the deed at any time. The deed only activates on the day you die. Let me show you what this saves. On a $400,000 house, probate fees run between 3% and 7% of everything you own. That means $12,000 to $28,000. Your children pay that before they even touch the title. The transfer on death deed takes probate off the table for that house. The county recorder simply transfers the title to the named person. No attorney fees, no 6-month court process, just a piece of paper that did its job. This form is currently available in 29 states: California, Texas, Florida, Nevada, Arizona, Illinois, Ohio, and 23 more. If you live in one of those states, you can file this deed tomorrow morning. If your state is not on the list, stay with me. The second document on this list was built for exactly that problem. The cost is small. The county recording fee is between $50 and $200. An estate attorney will draft the deed for $200 to $500. That is the entire investment. Compared to $12,000 to $28,000 in probate fees, this is a decision that pays for itself the day you sign it. The biggest mistake families make is signing the deed and putting it in a drawer. A deed that is not recorded with the county is a deed that does not exist. The county has to know about it, or it never happened. If your family finds the deed after you die but the county has no record, the probate court runs as if the deed was never signed. The IRS treats the house as part of your estate. The whole protection disappears. Good news here. You can sign this deed tomorrow. You can sign it 10 years from now. There is no health requirement. There is no age limit. But there is an IRS clock. The moment you die, the IRS has 9 months to file a claim. If the deed is not on file at the county when that clock starts, the IRS treats your house as taxable estate property. File it this week, not next year. This week. The second document is the Ladybird deed, and it is the one that protects your home in the states where the transfer on death deed does not work. The Ladybird deed is a special version of a regular deed. It lets you keep full control of your house while you are alive. The day you die, the deed automatically transfers the house to the person you named. No probate in most cases, no court appearance for your family. Why this matters? In a regular deed, the moment you sign it, the house legally belongs to the other person. If you sign your house over to your daughter today, she owns it today. And if she gets sued or goes through a divorce, your house becomes part of her legal problems. A Ladybird deed does not do that. You keep 100% ownership. You keep 100% control. The deed only activates on the day you die. Here is how it works. You sit down with an estate attorney who practices in your state. You tell the attorney the name of the person who should inherit your house. The attorney drafts the deed. You sign it in front of a notary. You record it with the county. You pay a recording fee. The deed sits in the county records. Nothing happens with it until the day you die. At that moment, the house skips probate and goes to the named person. That is the entire job. The dollar savings are similar to the transfer on death deed. On a $300,000 house, probate fees run between $9,000 and $21,000. The Ladybird deed eliminates almost all of that, and there is a second benefit most families never hear about. The Ladybird deed also protects your house from Medicaid estate recovery. That is the program that lets the state take your house to pay back Medicaid benefits you received during your life. The Ladybird deed moves the house outside that program. That alone can save your family $40,000 to $70,000 in long-term care costs. The Ladybird deed is currently recognized in 5 states: Florida, Texas, Michigan, Missouri, West Virginia. If you live in one of those states, this is the document to focus on. If you live elsewhere, the living trust is the next form. That is the one that works everywhere. The recording fee is between $75 and $200. The attorney fee to draft the deed is $200 to $500. That is the total cost. Compared to $9,000 in probate and up to $70,000 in Medicaid estate recovery, this is a $300 decision that protects hundreds of thousands of dollars in family wealth. The biggest mistake is signing the deed without recording it. Same mistake as the transfer on death deed. Same consequence. The deed sits in a drawer. The county never gets the notice. 6 months later, when the estate is opened, the deed does not exist in the county records. The second biggest mistake is signing a Ladybird deed in a state that does not recognize it. The deed would not work there. Always file in the state where the house is located. That is the only place the deed has legal authority. Like the transfer on death deed, you can sign a Ladybird deed anytime before you die. There is no health requirement, there is no age limit, but there is an IRS twist. The IRS has a 9-month clock after your death. If the deed is not in the county records before that clock starts, the IRS treats the house as part of your taxable estate. The protection disappears. File it this week. The third document is the Revocable Living Trust, and it does something neither of the first 2 documents does. It lets you write specific instructions about what happens to everything you own, not just the house. The trust is a legal container you create during your lifetime. You put assets into it. You write the instructions for how those assets should be handled, and then the trust runs those instructions on autopilot when you die. What makes the trust special is the word revocable. Revocable means you can change your mind at any time, you can add new assets, you can remove old ones, you can rewrite the instructions, you can cancel the entire trust if you want. The trust is yours to shape for the rest of your life. It only becomes permanent the day you die. While you are alive, you stay in charge. Here is how it works. You sit down with an estate attorney. The attorney drafts a trust agreement that names you as trustee while you are alive. The attorney names a successor trustee to take over when you die. You sign the trust agreement. You transfer the deed to your house into the trust's name. You transfer each bank account into the trust's name. You transfer each investment account into the trust's name. You name who should receive each asset, and then you live your life. The trust sits there. Nothing happens with it until the day you die. The cost is the highest on this list. Attorneys charge between $1,500 and $4,000 to draft a basic trust package. Most packages include a pour-over will, a durable power of attorney, and a healthcare directive. But here's the comparison. A basic probate case for a $400,000 estate runs between $12,000 and $28,000 in attorney fees alone. The trust costs $1,500 to $4,000 once. It never needs to be redone. Over a lifetime, the trust saves tens of thousands of dollars. Trusts work in every state. They are not state-specific. They are recognized in all 50 states, the District of Columbia, and every U.S. territory. The IRS also accepts trusts for estate tax purposes, as long as they are properly drafted and properly funded. This is the document that travels with you if you move. It does not break when you cross state lines. $1,500 to $4,000 sounds like a lot. But think about it this way. The average American moves 7 times during their lifetime. Each move is a chance for an estate plan to break. A will does not survive moves well. A trust does. A trust is portable. It moves with you. Each move would otherwise cost a family another $200 to $600 in will updates. The trust pays for itself by the second move. The biggest mistake families make with trusts is the most expensive mistake on this entire list. They create the trust and forget to fund it. They die with the house still in their own name. They die with the bank account still in their own name. They die with the investment still in their own name. The trust is empty. The court opens the will. The will triggers probate. The family loses $15,000 because they never retitled one document into the trust. The rule is simple. Every asset you want protected has to be retitled into the trust's name. Otherwise, the trust is paper in a drawer. You can create a trust at any age. You can create it tomorrow. You can create it next year. There is no health requirement. But there is a financial reason to do it soon. Every year you delay, your estate grows. And every year it grows, the IRS has a bigger claim against everything in it. The longer you wait, the more assets the government can reach. File the trust before the estate size gets bigger. The fourth document is the updated will, and this is the one most seniors think they already have. 9 out of 10 adults over 60 have a will. Half of those wills were drafted more than 10 years ago. Most of those wills mention people who are no longer alive, or no longer in the family, or who live in places they do not live anymore. A will that names your ex-spouse or your sister who passed away in 2019, or your son who moved to Australia, is a will that creates a probate fight instead of preventing one. The will is the document the probate court follows when there is no trust. If you die without a will, the state decides who gets your stuff. The state has a formula. The formula treats every child equally. The formula treats unmarried partners as strangers. The formula does not know you wanted your daughter to stay in her childhood home. If you do not write the will yourself, the state writes one for you, and you will not like the result. Here is how a will works. You sit down with an estate attorney, or you use a reputable online service. You name the person who will manage your estate. The legal term is executor. You list everything you own and who should receive it. You sign the will in front of 2 witnesses, you store the original in a safe place, and you review the will every 3 to 5 years, after any major life event, a birth, a death, a divorce, a move. Any one of those events means the previous will is no longer accurate. The cost to update a will is the lowest of any document on this list. A basic will drafted by an estate attorney costs between $200 and $600. A will drafted online and reviewed by an attorney costs between $50 and $200. Compared to what happens with no will at all, where the state decides everything, the cost is small. The state typically gives the smallest slice to the people you would have wanted the most. Wills work in every state. But the inheritance formula changes by state. In Florida, the formula favors the surviving spouse differently than in California. In Texas, community property rules apply. In New York, the rules are different again. So, a will drafted in one state does not always make sense in another. If you moved across state lines in the last 10 years, your will may be out of date. Not because your family changed, because the law changed, and here is the hidden cost. A will can be contested in probate court. A will contest runs between $10,000 and $50,000 in attorney fees. Most contests happen because the will is old. The will names someone who has died. The will does not mention someone who was born, or the witnesses cannot be found. Each one of those is a reason a judge lets the contest proceed. Updated wills are harder to contest. They are fresh. They have living witnesses. The biggest mistake is treating the will as untouchable once it is signed. Wills are not sacred objects. They are living instructions. They should be updated every 3 to 5 years. A will written in 2005 is wrong for most families in 2024. People have moved, people have married, people have divorced, people have died, people have been born. The will that honored your wishes in 2005 probably does not honor them today. And that is the will the court will use. No medical window here either. You can update your will tomorrow. But there is an IRS window most people never hear about. The IRS gives your family 9 months from the date of death to file Form 706 if the estate crosses the threshold. If your will is out of date, your executor may not know who should be filing that form. That confusion costs thousands of dollars in penalties. Update the will before your family needs it. The fifth document is the one I told you at the beginning of this video, that 9 out of 10 seniors have never even heard of. If you only file one document on this entire list, make it this one. The durable power of attorney is the document that tells the world who is allowed to make financial and legal decisions on your behalf if you become unable to make them yourself. That moment when you cannot make your own decisions is not when most seniors think it is going to be. It is not at the end of life. It can be next year, it can be next month, it can be after a fall, it can be after a stroke, it can be after a surgery that did not go as planned. The durable power of attorney covers everything from paying your mortgage to handling your investments. It covers filing your tax returns. It covers signing contracts for you. It covers selling your house if it ever becomes necessary. It is the most powerful document in estate planning after the will itself, and it is the one most likely to be missing on the day the moment arrives. Here is how it works. You name a trusted family member or friend as your agent. You name a backup agent in case the first person cannot serve. You sign the document in front of a notary. You give a copy to the named agent. You give a copy to your bank. You give a copy to your attorney. And then the document sits in a drawer. Nothing happens with it until the day you need it. When you need it, whoever you named steps into your shoes and acts on your behalf. The cost is between $100 and $300. That is the entire cost. Compare that to what happens without one. You are 72. You have a stroke. You wake up 2 weeks later in a hospital. You cannot speak. You cannot sign your name. You cannot pay your bills. You cannot access your bank account. Without a durable power of attorney, nobody has automatic legal authority to act for you. The only path forward is a court-ordered guardianship. That guardianship is one of the most expensive things that can happen to a family, short of an actual house fire. The court filing fees alone run between $1,000 and $3,000. The attorney fees for the hearing run between $3,000 and $10,000. The annual accounting and reporting that follows adds another $1,000 to $2,000 per year for the rest of your life. And during all of this time, the court is making decisions about who is allowed to do what. A judge is reviewing your medical records. A judge is approving or denying your daughter's request to refinance the house. A judge is managing your finances from 1,000 miles away. None of this happens if you have a durable power of attorney signed and filed before the stroke. The durable power of attorney is recognized in every state, but the rules vary. Some states require the document to be re-signed every few years. Some states require the agent to file a notice with the bank before the document is honored. Some states require 2 doctors to certify incapacity before the document activates. The rules are different in California, Texas, Florida, New York, and every other state. Talk to an attorney in your state about the specific rules. Do not rely on a form from another state. It will not work the way you think. $100 to $300. One-time fee. Covers every scenario. Signed once. Valid for years. Some attorneys include it as part of a trust package. If your attorney quotes you less than that, ask whether they are skipping the healthcare directive. Both documents usually go together. The biggest mistake is signing a generic form from the internet. Those forms may not work in your state. They may not give your agent the powers you actually need. They may not include banking authority or real estate authority or tax authority. They may not be recognized by your bank. The morning your daughter walks in with the document trying to pay your mortgage. Banks reject generic forms every single day. Always have an attorney in your state draft the durable power of attorney. And here is the window nobody tells you about. The durable power of attorney has to be signed while you are still mentally competent. While a doctor would describe you as sharp, while you understand what you are signing, the moment a doctor questions your capacity, the window closes permanently. You cannot sign a durable power of attorney from a hospital bed. You cannot grant one after a judge has already appointed a guardian. You cannot grant one after the court declares you incapacitated. The window is open right now. It is open until the day it is not, and nobody can predict that day in advance. And here is the IRS connection that closes this out. The IRS gives your family 9 months after you die to file Form 706, but the IRS gives them no clock at all to deal with incapacity. If your durable power of attorney is not signed when the incapacity hits, your family has to file for guardianship. During the same period, they are settling the estate. 2 legal systems running at once, 2 sets of attorneys, 2 sets of fees. Most families cannot afford both. Sign the durable power of attorney this week. That is the entire closing argument. The 6th document is the homestead exemption, and this is the one that is costing you money right now. Not when you die. Right now, this month, every month, while you are still alive, watching this video. The homestead exemption is a reduction in your property tax bill. In most states, it is available to homeowners over 65, to homeowners with disabilities, or to homeowners with limited income. And most of the people who qualify have never filed for it. What it does is reduce the assessed value of your home before the county calculates your property tax. Every state has its own version. Some states exempt the first $50,000 of value. Some states exempt the first $200,000. Some states freeze the assessed value the year you turn 65. Some states offer a complete exemption for veterans and their surviving spouses. The details are different in every state. The result is the same. You pay less. Here's how it works. You go to your county assessor's website, or you walk into the county assessor's office. You fill out a 1-page form. You attach a copy of your driver's license. If you are filing for disability, you attach a doctor's letter. You mail it in, or you drop it off. And then your property tax bill shrinks the next billing cycle. You do not need to refile every year in most states. You do not need an attorney. You do not need to be a veteran in most states. You just need to qualify and ask. Let me show you what this saves. The average homestead exemption saves between $500 and $3,000 per year on your property tax bill. On a $300,000 house in a state with a 1% property tax, that is $3,000 per year. Over 10 years, that is $30,000. On a $500,000 house in a state with a 2.5% property tax, that is $12,500 per year. Over 10 years, that is $125,000. The counties do not send you a letter. The counties do not advertise it. The counties collect the full bill every year from people who could have been paying half. Every state has some form of homestead exemption. Some are more generous than others. Florida has one of the most generous exemptions in the country. Texas has a generous school district exemption. California has a senior exemption that pauses assessment growth. New York has the STAR program. Pennsylvania has a statewide homestead exclusion. If you have not looked up your state's version, you are almost certainly overpaying this year. 0. The homestead exemption is free to file. The form is at the county assessor's office or on the county assessor's website. There is no recording fee. There is no filing fee. There is no attorney required. The cost of doing nothing is losing $500 to $3,000 every single year for the rest of your life. The cost of doing something is $0. The biggest mistake is assuming the county has automatically filed you. The counties do not automatically file anyone. You have to ask for it. And the first time most people ask is when a neighbor mentions it over a backyard fence, and they realize they have been overpaying for 10 years. Go to your county assessor's website. Search the word homestead. Read the first 3 results. File the form before your next tax bill arrives. That is the closing argument for this entire list, and for your checkbook. Here is what you do this week. Pay attention, because every day you delay is another day the IRS clock can start without you being ready. First, find your house deed. It is in your filing cabinet, or it is in a fireproof box, or it is registered with your county recorder's office. Find it. Put it in front of you. Touch it. That is the document that decides whether your home goes through probate or skips it. Second, write down which of these 6 documents you already have and which ones you do not have. Be honest with yourself. If you do not have a durable power of attorney, write that down first. It is the document with the shortest window. It is the one that protects you while you are still alive. Third, for any document you do not have, search the name of the document plus the name of your state. Search Transfer on Death Deed California, or Lady Bird Deed Florida, or Homestead Exemption Texas. Read the first 3 results from your state's official websites. Do not rely on blog posts. Fourth, call an estate attorney in your county. Ask for a 1-hour consultation. Tell the attorney the 6 documents on this list. Ask which ones you are missing. The cost will be between $200 and $400. That is the price of an unlocked door. Fifth, do not put this off. Every one of these documents has a window. Every one of those windows closes the moment something happens to you. The IRS gives your family 9 months after you die, not a year. 9 months. And every one of these documents beats that clock. But only if it is filed before the day it is needed. 6 documents: Transfer on Death Deed, Lady Bird Deed, Revocable Living Trust, Updated Will with Tax Planning Language, Durable Power of Attorney, Homestead Exemption. Each one does one specific job. Each one costs less than $500 to put in place. Some cost nothing. Together they form a wall between your family and the IRS, between your savings and the probate court, between your dignity and a courtroom where a judge has never met. You has to decide what happens to the home you worked 40 years to pay off. The best thing you can do right now is send this video to one family you love, who has aging parents. That one share might save them $20,000. Most of these documents cost less than $200 to file. But if nobody tells them about them, the IRS gets the house. If you are not subscribed yet, do that right now and hit the bell. Estate planning rules change every year. When they change, I break down exactly what it means for your home and your family. That is what this channel is here for. Go find your deed. Check which of the 6 documents you already have. Search what you are missing by name plus your state. Call an estate attorney in your county. Ask for a 1-hour consultation specifically about home protection from the IRS and from probate. Then file the forms you are missing. That is how you protect the home you worked 40 years to pay off. Do not put this off until next year. Every window closes the moment something happens to you. Once you are in the hospital, once the court gets involved, once a doctor questions your capacity, none of these forms matter anymore. The IRS has 9 months. You have today. The time to act is now.